Hello everyone, we should be making a start now. So a warm welcome to you all and thank you very much for joining us today. I hope everyone's feeling well and are settled in for the next hour or so. In case you haven't joined us before, we do like to start by making a brief introduction. So for those of you that are familiar with us, bear with. But I am Karen Faulkner and I'm the HR Knowledge Manager at HR Solutions, and I am the presenter today. And I am joined by my colleague, Ateem Arden. She's our digital marketing executive, and she is here with me. If you were to have any technical problems, I mean, hopefully, of course, you will not, but please feel free to use your control panel to send her a message, and she's going to try and ensure that everything runs smoothly today. She'll also be monitoring and collating any questions, so do send her a message. I will try and get back to you at the end of the webinar. So hopefully today, but if not, certainly by the end of the week, I'd like to get back to you, and I do love getting them, so feel free to send them over. We are recording this session, as we always do, so you will be able to watch this again on our website, and if you would like a copy of the slides, they will be available on request afterwards. So again, please do get in touch with me and let me know. I'll be more than happy to send them over. So that's me then, you know who you're listening to. Let's make a start. So we're running a bit of a series at the moment to try and help organisations to minimise risk, and we're looking at various topics and things that affect HR, and today we're looking at safer recruitment. So these are some of the things that we are going to be covering over the next hour. I'm going to start by doing a bit of an introduction to the topic. We're going to look at GDPR, in case you've not had enough of that yet. We're going to look at safe adverts and interview questions, the vetting process, and also touch upon internal recruitment as well. So these are areas where we generally get most of our questions at the moment. So hopefully we will be able to iron out those for you if you have them too. So it is good to start out by thinking about what we're trying to achieve. So hopefully by the end of the webinar today, you will feel that we've met these two aims that we've got. So hopefully you'll feel more comfortable with how modern data protection law impacts on your recruitment process. And hopefully you will also feel a bit more equipped to deal with some practical things that you can do and implement to actually improve compliance and minimise risks in your process too. So as we go, I'm going to be almost providing a bit of a checklist of the things that you can take away to do. So hopefully it'll be quite a useful hour session. So let's start then. I wanted to begin by providing some foundation to this topic. Now, often employers are not totally sure what it is that they have to be mindful of when it comes to recruitment. It's one of those halfway house subjects, really, between dealing with members of the public and employees. So because questions around what a law affects recruitment and selection are quite common, it helps to navigate the questions by being aware of which areas of law might govern our practices here. So that means we can then categorise our questions accordingly and begin to find the answers. So there are four main areas of law which apply to recruitment. And these are data protection, discrimination or equality, contract law, and also employment law. Okay, now the focus today is going to be on the first two areas because they tend to be the key ones that will inform a recruitment process itself, and the other two tend to crop up more when we are in negotiation with somebody who we have offered. Okay, they can arise throughout recruitment, but tend to lay low until an offer stage. So we're going to be focusing on data protection and discrimination today. Now, legislation relating to discrimination, or rather equality, should inform all safe recruitment practices. So in this context, we are primarily concerned with the Equality Act 2010. And the General Data Protection Regulation and the Data Protection Act 2018 both put a fresh angle on data protection law, and they are actually requiring us to put tighter controls on our processes, and that does include a recruitment process as well. Okay, so the GDPR has been a bit more publicly advertised than the Data Protection Act. The Data Protection Act is the UK's answer to the GDPR. They both need to be read in conjunction with each other, but the Data Protection Act essentially implements the GDPR, which is an EU piece of law, here in the UK. All right. So we're going to start by looking at GDPR compliance. Now, organisations must ensure that their entire process of recruiting a candidate from end to end is compliant with the GDPR and the Data Protection Act 2018. Okay, and this begins from the point at which personal data belonging to a candidate is actually collected, right through to how this is ultimately removed from your business entirely. Okay, so from when you first get data about a candidate right through to when you clearing it from your internal systems and computers and things, you know, to do with a candidate, that is going to be your recruitment process from a data protection point of view. Okay. Now, today, we're going to try doing some polls just to try and get you involved a little bit more and thinking about this topic. So what I'm going to do is put this question to you and ask you to say whether or not you think it's true or false. Now, I'm not going to publish what each specific person has said. It's just for a bit of fun, and we'll just generally show, you know, what the overall response rate has been. So let's see how we go. What do you think to this then? We use a recruitment agency, and therefore they are responsible for GDPR compliance throughout the recruitment process, not us. Okay, so this is a question that we do get asked sometimes because organisations are thinking about which role in data protection they fall under, and they wonder whether actually if they involve a recruitment agency, then that recruitment agency takes the responsibility of data protection compliance. All right, so have a look at the statement. I am going to put up this poll now. So, do you think it is true they collect the data and so it is their responsibility? Or do you think it could be false? We're responsible once the agency gives data to us. So, I'm going to just give you a few moments to have a look at that and submit your answers. And I'm just going to give you 10 more seconds to get your vote in. We've nearly got everyone. What do you think? Okay, so I'm going to close that now. And let's have a look at our results. So all of you have put false. We're responsible once the agency gives data to us. That's fantastic. Yes, absolutely right. You might say it's a leading question, but hey, why not? We got it right. That's the main thing. So yeah, it's false. We are responsible as soon as data gets through our doors. We've got to look after that piece of data. So you're absolutely right. Well done, everyone. So I'm just going to close that off then. and we'll move on. It does mean then that you're all aware that you have to pay attention for the next few slides, of course, you realise. So let's have a look. I'm going to start first by talking about the actual process itself and getting that GDPR compliant. So it's a bit of theory, I'm afraid. But the basics of modern data protection law are as follows. Okay, so first things first, we have to have identified a legal reason. We have to have a legal reason to be able to even have personal data in our business in the first place. Okay, so you have to identify which one you're using, and there's 6 possible ones. Then you have to ensure that what you do with that piece of data is compliant with 6 fundamental principles of the GDPR. And that does require a bit of work, I'm afraid. You may be well aware of that already if you've got yourself compliant so far. And we also have to ensure that our process, that process from end to end, is private by design and by default. Okay, so hopefully once we've reviewed compliance with the 6 principles, we would have started to make our process private by design and by default. But it is forcing quite a lot of people to revisit their recruitment process and think about what they can adapt and change or redesign to try and make it a bit more secure and GDPR friendly. Those are the main things, but there are some other obligations to be adhered to, and the most applicable ones in the context of recruitment at least are the need for us to provide privacy information to a candidate. Okay, so as soon as we collect data about a person, we have to have issued them with certain information, and this is called privacy information. And any process that collects data as well ought to have a record of processing activity. Okay, so employers need to be keeping these. Arguably, you know, recruitment, you might say, well, we're not yet the employer, but there are many reasons why actually this is likely to be applicable, and certainly you are going to hopefully end up with an employee at the end of it, and so again it will be applicable because of that person at least. Now, as part of becoming GDPR compliant, in theory, organisations should have already got to grips with these things on screen, you know, especially if you were trying to get ready for the 25th of May when the GDPR was enforced. If not, if you're still doing it, I do not think you're alone by any means. Everything that I have highlighted in bold here, we have actually covered it in greater detail in other webinars. So please do have a look at our website and select ones that you want to find out a little bit more about, and they go into a greater level of detail. I think particularly perhaps privacy information is something that people are still not quite getting right, and I've had some feedback that that webinar is helpful. So not just me complimenting myself, but you might find that helpful too. So have a look at those things. Once you've done this, then you've kind of got the theory out of the way. Okay, you should be set up with a GDPR compliant data protection process, and that's pretty much it for the theory, apart from one last thing which you might want to do, which is getting ready in case something goes wrong. Stuff always goes wrong, we know this, and you need to be ready and set up to deal with potential breaches or potential incidents where your security measures that protect your data might have been compromised in some way. Okay, so please remember that as part of being GDPR compliant, your organisation ought to be set up so that any incident to a security measure can be reported and can be logged by your staff. Okay, incidents are always going to happen, and they are things that might not necessarily have to be reported to the Information Commissioner's office. You know, for example, leaving a set of keys in a cabinet which contains private personal data that we're protecting, you know, or leaving a computer screen unlocked. You know, these are potential incidents because those are things that are potentially making your data secure, but they might not lead to anything serious. But your staff need to be logging them, okay, so that you can demonstrate that you're aware of your measures and you are protecting data. And of course, some of those things could result in a serious breach. Now, arguably during a recruitment process, things are more likely to go astray. You know, if you were to share a CV, let's say, with the wrong person on an email, you've potentially published or shared a great deal of private data about somebody to someone outside of your organization who should not have seen it. And it's going to be these communications where things go wrong. You know, any communication between A and B is where someone can intercept or where they can get lost or go astray. You're also going to have people who are essentially strangers, you know, turning up for interviews. You don't know who they are. You don't know what their motives are. They could see something they're not supposed to see. They might not even be who they say they are. You know, they might have ulterior motives, because it does happen more than you might think. So the only other thing that we need to focus on is the fact that actually we might be vulnerable as we deal with the public during recruitment. So please make sure you have got things set up to deal with reporting and logging incidents and breaches. So that is the more sort of theory side, the prep of your process. But I think there are some common areas that crop up in recruitment on a day-to-day basis that are particularly impacted by modern data laws, including references, health and criminal records, and also equal opportunities monitoring. So as we get to grips with the GDPR, these are areas which we seem to be getting questions on. So we're going to focus on these a little bit more. So with a reference, we're pretty used to handling references in two directions, providing one and then asking for a reference, because we usually make job offers subject to receipt of satisfactory references. Let's look at providing a reference first, okay? Now, if you're providing a reference, someone's probably contacted you and said, you know, can you tell us a bit about Joe Blogs, or whoever it might be. Please don't fall in the trap of assuming that you can rely on implied consent, okay? This is a thing of the past. Regardless of whether that person asking has got their own consent or has got another legal basis which enables them to try to obtain information from you, that doesn't mean that you also have the green light to give the information, okay? So my top tip here is to contact they're probably your ex-employee, get in touch with them yourself and obtain your own explicit consent using a form which is GDPR compliant, okay? Don't rely on somebody else having got it right, and even if they have got it right, it does not mean that you are safe to go ahead and issue it, okay? So get your own explicit consent from your ex-employee. And I've got another tip which might actually make this a bit less cumbersome for you, but you could consider building into your leaver process, actually providing a leaver with a reference that you're happy to give. So consider putting something, you know, on your company headed paper that they can actually go and take to prospective future employers themselves, you know, and they're free to issue it to who they like, aren't they? And you know, you don't then have to worry about trying to get consent from them, or you know, worrying about trying to get hold of them to get consent and so on and so forth. You've already got it sorted. So that's another tip that you might find quite helpful. Now, if you're part of an industry where you have a statutory or legal obligation to provide a reference, then that will supersede your need to get consent from that person, okay? And if you're wondering whether or not that applies to you, then it probably doesn't, okay? Because you are almost definitely going to be aware if you've got a legal obligation on you to provide references, okay? It tends to apply to things like the financial industry, sometimes in care as well. So if you do get a reference request, get explicit consent, which is compliant with GDPR, okay? Now, if you are asking for a reference, then again, consider any reference letters. You might have a template letter, or a template reference request form. Review it and consider whether or not it meets the 6 principles of the GDPR, okay? One of those principles is minimization, okay? That we should only be asking for information that we really need. Now, you might just be verifying that what somebody's told you already, is true, but you're still getting data back from somebody. And it's quite often that you get new information on that reference as well, if you've actually managed to get one, which is becoming rarer these days. I think you might agree. So if you do have a template letter, or as you are writing to request for a reference, please consider what you're asking for and whether or not you really need to know the answers to be able to offer somebody a job, okay? Hopefully your interview process is robust enough, or if not, you could perhaps think about how you might be able to improve it so that actually there's not a lot left to learn about a person from a reference, and anything else you need to know is probably just, putting them to the test, really, by actually putting them in the job. And then that really is what we look at using probationary periods for, so remember that you can iron out any issues with performance, with lateness at that point. Now, I would strongly advise that you avoid relying on consent when you are asking for a reference, okay? So don't sit in front of a prospective employee or somebody that you have appointed on their first day and say, sign this form giving consent for me to get references for you, okay? I've got a webinar on this already, but just to reiterate, as the employer, you are not able to rely on consent due to the imbalance of power in the relationship, okay? So once you are the employer, consent is not an area for you whatsoever, okay? So there is no need. It should be a relief, hopefully, for many of you. It should be a relief, but you don't have to worry about getting consent that's GDPR compliant or any of that malarkey, okay? You can rely on having a legitimate interest, potentially, unless you think actually we don't need references at all. Many people are finding that they don't get any useful information back anyway these days, because we're worried about giving a bad reference, and somebody suing us, for saying something defamatory about them. So we don't tend to get a lot anyway, and now we've got GDPR to contend with too. So you might even just want to consider if you need a reference in the first place, but if you do, that's fine. I'm not saying that you have to stop asking for references at all, but please do just ensure that you are only seeking confirmation or new information that you really need to know, okay? I think the fact that we have to be so specific about what we're asking for does mean that it is quite difficult actually to prepare a template that's a one-size-fits-all in respect of a reference, because what you might need to know could vary massively, not only between industry, but even between job roles, So unfortunately, it is difficult to provide that one-size-fits-all template, and it is something we're probably going to have to always just be a bit savvy and wise to every time we ask, I'm afraid. But just bear in mind you at least don't have to ask for consent. And one last tip on this, something that is sometimes missed. But the GDPR does say that if you should find out any new information about a person, then you have to tell that individual pretty promptly. Okay, so if you get a reference back and you find out something new, quite often we find out about health conditions this way. Someone might not have disclosed something and a reference says, you know, they were off for X amount of time due to this disability. You know, we then have an obligation on us to let the candidate know that we know this about them now. So try and think of how you can build into your process a trigger that makes you think, right, check reference, anything new, tell individual. So that is it on references. We're going to have a look now at health and criminal records. This is a bit of a smaller subject for us to dwell on, but the Data Protection Act has made it an offence now for an employer to require a candidate or an employee to provide them with access to health or criminal records in connection with recruitment. Okay. Now, it's a very common practice for us to issue health questionnaires, particularly, you know, when we've perhaps appointed and things aren't still confirmed, and some employers are still wanting to ask that question at interview stage as well. You know, this makes it very clear, really, that if you are forcing somebody to do that, then that is actually now potentially a criminal offence. So you must avoid it. Unfortunately, you know, as organisations, we're not always just thinking about employment law. I appreciate that. Sometimes, you know, you might be thinking about defence of a personal injury claim. You know, have we tried to find out information to put support in place to avoid injury of somebody? So, you know, you can ask, but you must not require somebody to provide this information, okay? And it was the case before, but it is now an offence to require it. Now, there are some exceptions, aren't there always? But the exception is if you need it because of another legal obligation. So again, finance industries, care industries, you know, police, you might need criminal records in those areas and so on and so forth. And again, you will know if you are subject to a legal obligation. Or you might need it because you've been ordered by a court or tribunal to get a reference, or you might need it because it's justified as being in the public interest. Again, another reason which makes it okay for care industries to ask for this information. And equal opportunities monitoring then. So this is bringing our data compliance section to an end, and I think it lends itself quite nicely to lead on to our next subject areas. But under the GDPR, if you don't know already, processing sensitive data, or special category data as it's known in the regulation, is actually prohibited totally, okay? Fortunately, for the purpose of employment, it is allowed. And one of the explicit reasons that processing sensitive data is allowed is to carry out equal opportunities monitoring. So if you were worried that you can't do that anymore, don't be. You can still do that, okay? But we must be all the more robust about ensuring that we are doing it properly, okay? And that means that we are doing it for the right reason, okay? Which is this: the data that we're collecting must be necessary for the purpose of identifying an existence or an absence of equality of opportunity or treatment, okay? And that must be with a view to then enabling equality to be promoted or maintained. Okay, so if you've kind of lost sight of exactly what equal opportunities monitoring is all about, I think we all probably think we can guess the reason, but it's this sentence and phrasing specifically that we've got to be working towards. Okay, and we can only process certain bits of sensitive data under equal opportunities monitoring. Okay, and there are 4 categories altogether: racial or ethnic origin, religious or philosophical beliefs, health, and sexual orientation. Okay, so that is not everything that's covered by the Equality Act, if anyone's wise to that. It's just these 4 things, okay, and it must be in respect of that sentence above there. Now, if processing sensitive data, okay, in the context of equal opportunity, any of the following situations came up, then you would not be allowed to continue processing the data for monitoring, okay, for individuals in this respect. So it would not be allowed if the purpose was to make a decision about an individual or to put measures in place in respect of an individual, okay. So there is a word missing there, so it's decisions or measures about an individual, or if the monitoring would cause substantial damage or distress to an individual, or if a person has given you notice in writing, okay, that they wish for you to cease monitoring data for this reason, and that notice period has come to an end, okay, then you would not be allowed to continue to process any of that sensitive data under the umbrella reason, if you like, of equal opportunities monitoring. And just to remove any lasting doubts, anyone who's still trying to cling on to consent, okay, consent is not required in order for you to conduct equal opportunities monitoring. And as I said before, as an employer, you cannot rely on it anyway. Even if you got consent, it wouldn't stand up in a court of law, okay, because of the imbalance of power in the employer-employee relationship. So you do not need to get consent when you're doing your equal ops monitoring. So there we are. We've just got through our data section. And I'm going to give you a summary, so a bit of a tick list that you can take away in case I lost any of you at any point during that. So firstly, identify what your legal reason is, okay? There are 6 possible excuses to have data in your business. Pick one of them, and I've done the work for you. It's legitimate interest, okay? It's not consent, and the other ones are so unlikely to apply. When you are recruiting, you've got a legitimate interest because you have probably got a genuine vacancy in your organisation that you've got to fill. And in order to fill that, we need to know 1 or 2 things about our candidates so that we can recruit. So your legal basis is legitimate interest. And you need to be checking that your process then, your end-to-end process is compliant with the 6 principles, okay? So this is different from the 6 reasons. The 6 principles of GDPR should apply, okay? Then you need to be building into your recruitment process a point at which you issue privacy information to your candidates, okay? So as I said, there is set information that you must give an individual when you're collecting data, and this is called privacy information. You must be keeping records of your processing activities. So this is about your actual recruitment process itself. What is going on? What do you collect? When, how, where, and why? Who's responsible for it, and all sorts of various things. So please do have a look at our webinar on that. You've also got to be ready to log incidents and breaches. And as I say, your staff really ought to know how they can help you do that, because you as one standalone person, or even a few of you, are not going to be able to log everything. And if you are obtaining if you are providing a reference, please obtain your own consent from your ex-employee, okay, before you give that reference. Don't assume that you're okay to give it because somebody's asked for it, or because somebody's saying to you, well, I've got consent from that person to ask you. They might have consent to ask you, but you don't automatically then have consent to give it. Don't obtain consent in order to ask for a reference, okay? And if you do get any new information when you receive a reference back, then please build into your process a point at which you're prompted to let them know, so you don't forget to do that, okay? And then don't ask for, or don't require somebody to provide you with health or criminal records, okay, unless you have a legal obligation to do so, okay. So I've put do not ask, but I mean don't require and don't force somebody to do it, okay. If possible, avoid asking, but I think there are several reasons why you could still ask for that information. And then lastly, if you do equal opportunity monitoring, please ensure it's compliant in the ways that I listed on the previous slide, okay. Now, I've also just put on screen several areas in which we can support you with becoming compliant or with templates, so that you don't have to sit in bed at night and read the General Data Protection Regulation and design your own forms, okay? We have things ready to go, like privacy information templates, like GDPR compliant consent forms, like impact assessments, which will help you to ensure that you are meeting the 6 principles, and will help you to ensure that your process is private by design and default, okay? So if you would like that, please do drop me a line and let me know. So we're moving on then now, moving on swiftly to the not lighter subject of discrimination, okay? So safe adverts and interview questions. Naturally, we are particularly focusing on unlawful discrimination, and this is namely governed by the Equality Act 2010, okay? So we're looking at unlawful discrimination in respect of adverts and interview questions. Now, before we can really consider how to make our adverts and interview questions safe, we need to be clear on what would be unsafe. All right, so the most important thing I would say to always bear in mind is the characteristics a person can possess which are protected from unlawful discrimination, okay? And there are currently 9 characteristics altogether, okay? And actually not many people can list all 9, or certainly not use the wording that's used in the Equality Act anyway. So I'm going to provide them for you here. We have age, we have disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. Okay, so those are our 9 protected characteristics, and we should always consider whether what we do, say, present, or imply, and so on and so forth, could potentially put someone at a disadvantage because of that characteristic. Okay. Now, we're going to do another quick poll just for fun. So what do you think about this statement? It's something that we quite often get told to us on our advice line, okay? When we're warning about discrimination inadvertently, someone might say, well, hang on a minute, I'm female, or hang on a minute, I'm gay, so I can't have discriminated against someone that's also those things, can I? And actually, sometimes they've hit upon something there. So I'm going to see what you think. Do you think I'm leading you, or do you think I'm not? I'm not bluffing. I'm going to put a poll on screen then for you again now, and give you just a moment to have a look. So do you think actually maybe that is true? That is pretty good defense against discrimination. How can I discriminate against somebody the same as me? Or do you think it's false and actually this would not be a defense against discrimination? So have a little look there. I think we've got some of you hesitating. Remember, I'm not going to look and see how you voted, so don't worry about me thinking anything of you specifically. All right, we've nearly got everyone there, so I'm just going to give you a couple more seconds to vote, 5 more seconds. Great. Okay, so I'm going to close this now and share the results with you. So we have got a few people saying true and most people saying false. Okay. So the answer is false. Okay. The Equality Act does actually have a specific section in it which says that the person who's accused of discriminating can possess the same characteristic themselves. So I'm afraid that it is not a defence against a claim. Okay. So bit of an interesting one, and people are usually surprised to learn it. Though some of you probably thought maybe she's leading me. I'm going to stick on the safe side here, but good on you for being bold. Let's have a look then at how we can keep our adverts safe. There are a few different things we can focus on. So think about your language firstly, okay? Often when we are reviewing a job description for somebody or an advert, you know, we think about being in the shoes of someone with each characteristic, and sometimes there is language in it which points to somebody who might possess or not possess a particular characteristic. All right, so avoid saying things like he or she. Don't describe the ideal candidate as a he or she. Don't describe the ideal candidate as experienced or a school leaver. Okay. It might be surprising, especially the word experienced, but that does heavily imply an age that you might expect a successful candidate to be. And as such excludes somebody who might not identify, you know, with either of these phrases. So rather than just telling you what not to do, I am also going to put some things to try doing instead. So why not consider using more neutral language throughout? Describe the person as the ideal candidate, and say that, you know, this person will be able to demonstrate skills in, or will have qualifications in, or is likely to have qualifications in. Okay, because remember that although without even realizing we might have ideas in our head about who the right person is likely to be, or some characteristics that the person might have, it's very unlikely, you know, that this is always true. And in fact, it's the person with the right skills, the right qualifications, who presents themselves in the right way, who is going to be the best person for the job, regardless of the characteristics that they possess. Many adverts use imagery, okay, and there's still an awful lot of stock images which are not diverse, okay, particularly corporate stock images. So try and just be a bit conscious of this, try and be proactive in selecting ones which show a greater level of diversity or inclusiveness, you know, those depicting younger, older, people with a disability, people wearing religious dress, and so on. And consider the placement of your advert as well, okay? So sometimes this choice can actually be biased to certain groups of people. For example, putting an advert in a men's health magazine is more than likely to exclude most women. So consider that. There's also been a case where an internal advert was posted on a staff notice board, which was on the wall of a canteen, and it was not advertised anywhere else. Now, this notice board was actually at such a height that an individual, an employee who was a wheelchair user, was not able to see the advert, okay? So we really need to just think about putting our adverts perhaps in several different places, even if it's just 2 different places, you know, to really try and broaden the reach and broaden the scope and the likelihood that a more diverse range of people are likely to have seen it. And then let's have a think about interview questions as well. So it might sound very obvious, but it is wise to avoid asking questions which relate to a protected characteristic at the interview stage, okay? It is rare that this is ever going to have a genuine bearing on whether or not an individual is suitable for the role, okay? Now, the problem can arise when a question which does relate to one is asked and the applicant is unsuccessful. Okay. Now, if that applicant were to challenge why they were unsuccessful, okay, and if they were to put to you that it might be because of a protected characteristic, the burden of proof falls on the employer when it comes to direct discrimination, okay? So if you've asked about it specifically, you will really be setting yourself up potentially for a fall, okay? So it is very difficult for you to prove that you did not do something. It's very difficult for you to prove that you did not discriminate. So for this reason alone, you know, it is well worth avoiding asking the question altogether. Now, I've given you some examples, which I'm going to put up on screen, of questions that are likely to pose a risk, and some are more obvious than others, but avoid asking whether or not someone's taken a certain amount of time off work, you know, in the last few years. Avoid asking whether or not someone's got any plans to get married soon. Not only does that link to the protected characteristic of marriage and civil partnership, but sometimes, you know, it might indicate that, you know, we're expecting a female to get pregnant soon, maybe, who knows. Bit of an old-fashioned view, but sometimes, you know, it comes up and that's what people argue. Do you have any childcare commitments, and when did you leave university? Okay, all questions to be avoided. And instead of these, you might want to rather ask things such as, you know, why do you think you'd be good at this job? You know, do you have any questions for us? If they're concerned about anything that they might have, that they might struggle with, you know, they can ask you I would still probably avoid dwelling on it and say, you know, that we would absolutely be looking to discuss how we can support the right candidate who had something that they needed help with. But I'd even go so far as to say that you feel that actually, you know, you don't need to discuss that anymore at this point, and you'd rather focus on why they're the right person for the job, you know. If you really do have concerns, you might even want to say things like, you know, can I confirm you're aware that this is a full-time job or a field-based job or a nighttime working position, you know, just in case someone's not thought, well, actually, this job might not be right for me because of X reason or X condition. You know, if they realise it themselves, then at least you don't have to try and navigate it after the fact. So I'm just going to do a quick summary then on safer adverts and interview questions. Avoid language that might identify or exclude somebody with a protected characteristic in your adverts. Try and select inclusive imagery. Consider whether your placement of an advert is acceptable. And although we've not dwelled on it too much here, I think it's important to always bring up reasonable adjustments in respect of discrimination and equality. So please be open to making them to support a candidate with an application. Okay, and I'd even go so far as to consider advertising your willingness to do this, you know, inviting people to contact you to discuss arrangements to help them with application. You know, sometimes even just saying, you know, send your applications to the 10th floor, you know, implies to some people, well, I'm never going to be able to get up there. What if the job is based there? I can't get there. You know, they might not have a lift. How am I going to get up? You know, all these sorts of things. We shouldn't be ruling these people out. You know, logistics is something we work out after the fact, all right? Not something that we use to rule people out at this point in time. So let's look now at the vetting process. So this is all about making choices. Who do you want? Which one are you going to choose? Now, to minimize risk here effectively, you should know exactly why you have picked one candidate over all the others. Okay, so in theory, you will have picked the best person for the job, and that might sound obvious, but it doesn't always happen. And the important thing to be able to safeguard yourself is to be able to evidence that you selected the best person for the job after the fact. Okay, now we do this by keeping a log, and of course we're going to do that in a way that's compliant with GDPR. So yeah, if you want advice about retention periods and things like that, again, get in touch. And again, we can support with thinking about retention periods of all kinds of documents throughout an employee's life cycle. But keep a log of the objective reasons why candidates have or have not been successful, okay? And what you might do is consider using some areas which could be objective factors and perhaps even assigning a score to them. So it might be, you know, that 0 indicates this person did not demonstrate X, Y, or Z, and 5 indicates that they were that they excelled at demonstrating X, Y, or Z. And by quantifying performance in this way, you know, during an interview process, you're going to make it far easier to identify who that best applicant for the job is. So through your interviewing approaches, you know, which might include a telephone interview or a face-to-face interview, competency test, and so on, you might be able to determine desirable traits which are objective. And I'm going to list some of those things that you might be able to turn into objective criteria here. So you might work out what soft skills the job would ideally require, any qualifications that might be preferable, applicable experience. So remember that sometimes actually you might want someone who's completely fresh-faced and has perhaps come from a different walk of life, in a different industry, but could transfer skills. So it's not always about someone who is really experienced. How someone's presenting themselves, whether they've turned up with the right degree of formality that the job requires, or whether actually they've realised that your organisation has an informal approach and they're taking that on board in how they present themselves to you. And also fit, within a team. Think about what existing personalities and strengths and weaknesses you've got and where you could actually do with somebody to mix things up. Do you need somebody who's got a strong voice, who has got leadership skills, or do you actually need someone who's a bit more of an introvert, someone who's a bit more, willing to be led, or is a bit more of a thinker? Now, it's often here when we're deciding between who, is best for a job that unconscious bias crops up. Now, unconscious bias is something that's being discussed more and more at the moment. Some people are for it. Some people find, that there are reasons why we might not want to dwell on it too much. But effectively, what it is the unconscious sorting of things which are familiar or unfamiliar. Okay, and this is actually believed to be a survival instinct. It's a basic instinct which helps us to survive, between identifying what is safe or unsafe, familiar or unfamiliar, known, unknown, the same and not the same as us. And it is what is believed to generate this gut instinct. Okay, quite often people say, I had a feel about that person, and that's fine, but it may serve as well to be conscious of the fact that this gut instinct is sometimes someone who we identify with. It goes without saying that we're more likely to trust somebody who we feel is like us, because we might trust ourselves to do something and we want someone similar to us to do it. Okay, so just have a little bit of proactive thought about what your gut instinct might be caused by. So a quick summary on vetting. Document how candidates perform in the interview process and try and use objective criteria as far as possible to select the person who performs the best during your interview processes. And again, do maintain records, okay, so that you can defend a possible claim. It's always going to come up after the fact, isn't it? Something might come back to haunt you. So you do need to consider how long it's appropriate to keep something for. And again, this is something we can help you with. And last but not least, we come around to internal recruitment. Now, before I get underway with this subject, I'm going to run my last poll. So I'm going to give you the option to submit your answers now, but what do you think to this? Generally speaking, do you think employers are legally obliged to advertise a vacancy? And there are several possible answers for this, and I'd just like you to pick one. So do you think, generally speaking, employers are legally obliged to advertise a vacancy? So do you think the answer is yes, employers are obliged to advertise vacancies? Do you think employers must at least advertise internally? Or do you think employers must at least advertise externally? No, employers are not obliged to advertise vacancies. Or I've given you a safe route if any of you feeling a bit, trial today. I'm not sure. So see what you think. I'm just going to give you a few more moments to do that. I think we've got a lot of people divided on this one. Some hesitation. So I'll just give you 5 more seconds to make your minds up. All right, great. So I'm just going to look at closing that now. and let's have a look at where we got. Wow, so we really split opinion here. 24% of you, so about a quarter of you, think yes, employers are obliged to advertise vacancies, and another quarter think we must at least advise internally. Some of us externally only. We've got about 29% thinking no obligation to advertise at all, and 21% sat with not sure. Fair enough. Right, okay, that's really interesting divide, and it is something that we do get asked a lot, actually, so I did think it was worth putting it in today. The answer, drumroll please, is there is no legal obligation to advertise a role whatsoever. Okay, and it does tend to come as a surprise to a lot of people. So those of you that hit that, you know, well done to you. I don't know if it's something you've asked before, but you are right. Okay. Now, what this means is this means that when it comes to internal recruitment, you're actually free to approach a specific person. Okay. Now, I should always caveat, I'm afraid, just the nature of employment is that there's caveats to everything. There's no legal obligation to advertise a role unless you are perhaps subject to some other regulatory body which requires you legally to publish a vacancy internally or externally. Okay, but otherwise there is nowhere else in law that requires you to advertise a role. And so as before, you will know if you're subject to a regulatory body which requires it, but otherwise there isn't a requirement. So if you thought, do you know what, this vacancy is coming up and I know that Sue Brown is going to be perfect for that job, couldn't think of anybody better, let's not waste our time advertising or recruiting, let's get her in and ask her if she wants it, you know, you can do that, absolutely fine. The only consideration that you need to have in terms of legal risk is whether someone could argue that they have been discriminated by not having been approached. Okay. In terms of legal risk, you might ruffle a few feathers, but that's all you primarily need to be concerned about. So a quick summary to wrap up the content of today. You're not legally obliged to advertise and you can then target a particular person, but I think it's still reasonable based on what I've just said there for you to ensure that your reasons for thinking, wow, should be brilliant, you know. I say she because I like to promote women, especially this year, are objectively justifiable. You know, if you've got an excellent person for the job, pick that person. Even if you do have, you know, let's say it's a promotion and most of the people at the top of your organization are men. If you've got a man who is excellent for the job and you can objectively justify that, approach him, fine. Just keep records of why you've done it so that, again, if you are challenged after the fact, perhaps by Sue Brown, you can defend why actually he's, you know, got this, that and the other about him, and we need that in this post, you know, that's absolutely fine. So that brings us to the end of the webinar today. If you do have any questions, please send them over. I love getting them and talking about these things and discussing different people's situations and things like that. So don't hesitate. If you've got anything just niggling in the back of your mind that you'd like to clarify, pop them over to me. And if you are interested in how we can help you, particularly in the ways I identified, then let us know and we'd be happy to talk to you. We're getting social.